concerned, my lord, we are filing affidavits in all the matters. And pursuant to your lordship, may I just inform your lordship, pursuant to your lordship's directions, we have commenced the process of receiving applications. Surveys are being done, and we are about to commence the hearings also. But there has been 7 respondents in the fresh batch. 7 respondents. And the newspaper publications we have made in, my lord, Bortoman, Ajkal, Pratidin, then, my lord, Statesman, English, Times of India, then, my lord, there is 3 Hindi newspapers, and also, my lord, Siliguri edition, so to take care of the North Bengal edition. And Nepali also. And, my lord, also, my lord, your lordship was there in the affidavit. Your lordship will find, my lord, what we have done. My lord, we have given separate headings for separate, my lord, issues.
Given copies?
Yes, we have served. The copies have been served.
So what further prayer you are wanting to make?
There's an interlocutory application that's been filed.
Yes.
After the passing of the order by this Honorable Court on 6/5/2025, 5 other notifications have been issued during the pendency of these writ petitions, each of which have been placed before this Honorable Court to contend that they fall foul of the parameters which your lordships have held to be within the jurisdictional confines of the WBC. Each of these notifications now has the effect of altering the schedule that your lordships have struck down. There is no legislative measure yet, but these are now lists notified under the WBC Act of 1993. The consequence is now that there will be a legislative measure to reincorporate it into the schedule in the 2012 schedule, which may have to invite another legislative intervention. But I need your lordships time to indicate to your lordships that the entire process that's been undertaken while the writ petition is pending here is directly in derogation of what your lordships have held to be a compliant procedure with the requirements of law, with the requirements of the judicial mandate in Indira Sone and the rest of the judgments. I will indicate to your lordships as to how each of the decision-making process and the recommendations that's been made by the West Bengal Backward Classes Commission falls foul of all of the parameters which your lordships have indicated are necessary primary ingredients of a factual investigation. For once, there is no determined criterion published on what would constitute the social and educational backwardness. All of the data that has been placed before your lordship in the 700-odd page affidavit, except the public advertisements, rest of all the information is in the exclusive knowledge of the commission and the government. None of that has been placed in the public domain for any of us to participate meaningfully in the public hearing exercise. Each of these findings now will reinvigorate Schedule 1, which has been struck down by this Honorable Court. And there is a re-arrival, if I may say with respect, the reinventing of the wheel, albeit with the same flaws which your lordships have found to be inconsistent with the principles of 14, 15, and 16. If these notifications of reintroducing 140 communities again, as interspersed between Category A and Category B, have the effect of being incorporated into the schedule, we will have the same situation without following the procedure as indicated by this Honorable Court. So we have a revised process purportedly in pursuance of the liberty granted by the Honorable Supreme Court, but continues to be non-compliant with the foundational requirements which your lordships found are necessary for any justifiable action as of fact and as of law. I'll only take about 15-20 minutes to point out as to how each of these flaws vitiates the notifications which have been issued, which is now a process concluded as far as the fact inquiry is concerned. Now
But
the
that,
list...
Sir, how can you have to point it out through by, they have used a substantive affidavit in terms of our earlier.
Yes. As on date, my lords, what is now going to happen is there is a direction by a single judge of this court as to how to continue with the recruitment and admissions, which will have to be in accordance with the pre-2010 notified backward classes,
Yes.
which is required to be the guiding force. Now, if this supervening circumstance of finding 140 communities, which is a rehash of the same communities, without any supporting data, will have the state to conduct admissions or conduct recruitment on the basis of these new notifications while the writ petitions are pending here. Either
legislation is formally introduced, won't the notifications are just indicative, isn't it?
Well, it's in my respectful submission, the legislative intervention that is required now, especially after your lordships have held that the provision for making reservations is now occupied by the 2012 statute. There is a consequential legislative amendment. Either they will reintroduce Section 5, or there will be an amendment to Section 2H, which your lordships have struck down. But it is only a legislative consequence which does not involve any other fact determination, which is concluded here. The fact determination which will warrant a consequential
legislation deliberated in the legislature.
Now let's kindly see as to what is already accepted in terms of how the list, which is indicated as the list for the...
There are two aspects. One is as regards the recruitment and the admission.
Yes.
Yes.
To that effect, a single judge has passed on.
Yes.
From the affidavit which they have given you copy, does it appear to you that they would be inserting this?
Yes. I will indicate your lordships as to how it is a process in imminence. There is a communication which has been placed towards the end of the annexures, which says the Backward Classes Commission's report has been placed before the legislature for debate. But what was required to be done in pursuance of the operative directions issued by this Honorable Court was, before it could be notified as a list under the Backward Classes Commission itself, it has to be placed before the legislature. But the government accepts it now. 140 communities which have incidentally been part of the schedule have come back to being notified as backward classes lists, albeit for the 1993 Act within a period of 45 days. And all the insignia of it having been targeted at a particular religious denomination is writ large and continues to be writ large. And as of today, the sample size that is, the data that has been frozen, your lordships have held, there has to be a contemporary data. There has to be a quantitative and empirical and normative analysis of the surveys, which come to be placed before the Backward Classes Commission. And then there has to be an application of mind on what are the figures available of public employment vis-a-vis these segregated social groups, and then compare it with the existing groups that are there and arrive at a process of reservation. Your lordships are aware, between 2010 to 2025, apart from the initial 64, what was indicated again was an addition of 77 communities which have come to be by reason of 5A, and 37 communities which have come in by reason of the power to amend the schedule under Section 16, both of which have been struck down. Now, all of these communities have come back on the basis of this following survey. 50 households per district have been taken as a sample size for each of the communities. And 1,100 households have been verified for coming up with a data which will have the effect of providing for reservations to 35% of the population of the state of West Bengal. The 2011 census, my lords, which is the freezing point as was considered earlier, would have the figures of the population at about 8.5 lakhs and the targeted religious population of a particular denomination to be at 27%. Now, by projection of what could be done as a statistical imperative, it has gone to 10.45 crore, and the population percentage of this targeted religious community is about 30%. So we have 1,100 households straddling 140 communities, traversing 37 to 40% of the population to be provided with 17% of reservations, when admittedly the state's population figures are not available. The population figures of each of the communities which has now been found entitled to be recognized as SCBCs is not available. And the data which is collected in pursuance of the sampling survey, I will indicate to your lordships, is on the basis of enumerated parameters which does not satisfy looking at non-Hindu occupational groups, as has been pointed out by your lordships and Indra Swami. Now, this forms the statutory basis for inclusion into the lists under the 1993 Act. May I now invite your Lordship's attention to the 1993 Act.
Wishes to proceed with the application, then I would be obviously relying on this affidavit, which is now part of the record and which has been served upon them.
Are the issues raised in
Absolutely, each one of them, my lord, each one of them,
in your
each one of them. But if your lordship, my lord, may I just make it
Supreme Court hearing the matter.
Supreme July. Next month.
Next month, which date?
July 2025.
Page 44 of our affidavit, my lord, we have annexed the Supreme Court order. On the immediately on reopening, my lord, subject to correction, my lord, business, page 44 of our affidavit. Any of the affidavit your lordship may kindly take.
It is directed to be listed on a non-miscellaneous day in July 2000.
That's an NMD. That will be taken up, obviously.
So I will only be relying upon the affidavit filed by the Backward Classes Commission. For the purposes of the present submissions I make, I don't need a rejoinder. I will rely on the information furnished by them, the pleadings and the documents filed by them to indicate, without having to contest any of the factual premises or the conclusions they have arrived at by way of a rejoinder.
But can we go into that at
Yes,
stage?
yes, at this stage.
When Supreme Court, they went to Supreme Court, there is no stay.
Now, kindly see the reservation.
There is no stay, sir.
Yes.
So today they will place the report before the Supreme Court.
Yes, we are placing that.
The ground before the Supreme Court,
Yes.
that once the order has not been stayed,
Now,
question of this entire procedure is a nullity,
Yes.
because
Now,
it is in violation of our order.
yes. Now, kindly come to the interim order or the reserving of the liberty order of the Honorable Supreme Court and the Backward Classes Commission's understanding of the liberty that has been
May I
granted,
just bring...
as has been stated in the pleading.
Sorry, I'm so sorry.
Now, kindly come to page 47 of the affidavit in reply filed by the Backward Classes Commission.
Yes.
Opposition, sorry, affidavit in opposition.
Which matter?
In 111.
Triple
In writ petition number 111, Amol Chandra Das.
Yes.
Now, the Backward Classes Commission understands the liberty to be unhedged by the pendency of the Supreme Court proceedings as far as revisiting the entire matter is concerned. I will indicate to your lordships from the pleadings of the Backward Classes Commission, and I will place it before this honorable court that this is an exercise without prejudice to the contentions there, but in compliance of your lordships' directions in the division bench. And if they maintain before your lordships that it is in compliance with the division bench's recommendations, that SLP for the purposes of this exercise may not be relevant, because they are before this honorable court in pursuance of my writ petition saying we have taken whatever contentions we have taken in the SLP, but without prejudice to those contentions, on the basis of the advice received by the Backward Classes Commission from the learned Advocate General, they have decided to comply with your lordship's directions to proceed with a revisiting of the entire process. Now, if this is a revisiting of the entire process, that earlier identification having been eschewed, if this process is to result in the notification of the communities for the purposes of the schedule or for the purposes of public employment, the Supreme Court's canvas or the contours of SLP would not comprehend the present exercise which has been done. That is their understanding in the petition.
Without disturbing my learned friend, is it the contention that compliance of your lordship's order makes the SLP infructuous?
No.
Unfortunately, that is not the law.
That is not the law. But
therefore, everything is open before the Supreme Court.
Now, my lords, therefore,
and that is why the Supreme Court was informed.
I'll just make
because it creates an impact on very many things. My admissions, the other recruitments, promotions, everything. So we cannot, everything cannot come to a standstill. Therefore, my lord,
may I just make one submission?
Now, therefore, everything is before the Supreme Court. If my learned friends have any grievance, they have very many grievances. Let it, my lord, await at least till the end of July.
Now, my lords,
may I one submission? 1 submission.
1 minute. Let him.
May I make one submission? Your lordship was pleased to pass an order on 6th of May to continue with the process, having regard to the law laid down by your lordship at paragraph 360 of your lordship's judgment. We are complying with your lordship's direction. Now, my lord, if your lordship takes the applications, I do not want to argue on the applications without any affidavit. My lord, naturally, because my lord, pleadings are not complete. Even if we take the applications as they are, my lord, these applications are nothing but application for modification, variation, or vacation of your lordship's order. Nothing more than that. My lord, whatever, this is a second attempt made by the petitioners to stall the process. We want to comply with your lordship's direction. Obviously, my lord, the SLP is pending. We do not know what will be the fate of SLP. My lord, it is an argument of no, my lord, subject to correction by my learned friend. Perhaps this argument may not be correct because Supreme Court may either confirm, Supreme Court may also modify. So whatever reports we will be submitting, that would be a relevant material before the Supreme Court when the matter next comes up before the Supreme Court. Obviously, my lord, we are bound to place everything before your lordship because we are now in a process of complying with your lordship's direction. We are doing so.
There is a bit of a grey area, Mr. Mazumdar.
Right.
Whether the consideration or consideration of the propriety of the process undertaken by you
Absolutely.
will be examined by the Supreme Court or this court is what is being now, I understand,
But
being argued.
May I make my stand very clear? May I make my stand very clear?
Yes.
My stand is that I am complying with your lordship's direction. My lord, I am bound to, my lord, follow your lordship's direction and any further direction to be issued by your lordship. I am also bound to place all the material before your lordship, which I have tried to do so in my affidavits which I have filed today. So, my lord, the primary material is now before your lordship. There is no rejoinder to my affidavit. Now, my lord, this is now a second attempt. Now, as I pointed, I don't want to repeat myself. But, my lord, today, unless and until your lordship has the occasion to go through my affidavit and go through their rejoinder or their rebuttal. If there is no rebuttal, that is one thing. If there is rebuttal, then it is another thing. My lord, your lordship, perhaps subject to, my lord, I will stand corrected, will not be in a position to assess the entire process and to examine whether we have carried out the process in compliance with your lordship's directions or we have acted in derogations of your lordship's direction.
Mr. Counsel for the
Yes.
petitioner, what is it that
15
you
July
are
is the
praying
next date.
today?
Yes. Now, my lords, if they have stopped short of giving effect to their fact finding and placed the report either before this honorable court or the Supreme Court, one set of consequences would arise. They have acted on the fact finding done in pursuance of the liberty and have modified and amended the statutory lists under the 1993 Act. So therefore, if it is of no avail to argue for me today, I am asking myself a question. The admission schedule for the current academic year is on. The recruitments have been put on hold. Would the state government act on the present included list purportedly in compliance with your lordship's order? Or would the, I'm asking myself the question, or would the state be complying with the Supreme Mandal's order where the learned judge of this court has held that you have to revert to the pre-2010 notification for the purposes of conducting recruitment? It can't be that your lordships are disabled from scrutinizing it. It can't be that the Supreme Court will see it in July 2015. And in the meantime, a fait accompli will be provided to me where the newly reinvented, re-included communities.
No, they have given an undertaking. They will not do so.
No, that was, my lords, kindly see the undertaking in the contempt case, which is what your lordship's referring to.
That in all the departments,
Yes.
they will not be proceeding with any further.
Yes. Now, my lords, the admission schedule for the present academic year is in June. Now, if they are to comply with Supriya Mandal's order, then we are all happy with the consequences.
That has not yet come today.
Yes, my lords,
It has not yet come.
Yes.
That what will happen. The state has not disclosed, subject to what you say. What you are arguing is that by keeping the matters pending, they would be inserting the new set and they will be throwing it upon the pending selection and recruitment process.
Yes. Now, if that my lords, if the state were to say that this is only a revisiting exercise, so
interim protection you want.
I am saying that these notifications, which have the effect of reintroducing the communities your lordships have struck down, shall not be treated as OBCs for the ongoing admissions in 2025. Because now I am just indicating to your lordships, it is not a pure and merited simple exercise of fact finding. They have placed it before this honorable court to abide by the verdict, or they want to place it before the Supreme Court and await adjudication. They have gone a step ahead and actuated the statute by accepting these recommendations and notifying the lists. Kindly see the CAM that I have filed. Kindly see what is left for the state to do is to bring in a consequential 3-line legislative amendment and present a fait accompli to me. Your lordships have said under 2H of the 2012 Act, it is read down to be in consultation with the Backward Classes Commission. So the Backward Classes Commission is consulted by the executive government for the purposes of incorporating these communities for the list under the 1993 Act. So the same list will be actuated into the 2012 schedule and we will be shown.
Subject to approval by the
legislature. Now, in my respectful submission, these findings will be the legislative fact for the purposes of the proposed legislation. I am not interdicting legislation. It might come whatever stage it has to come. But this is not a pure academic exercise which has been undertaken by the state. It has resulted in a statutory consequence of the statutory list of OBCs being amended. As to whether this could have been done on the factual premise that has been undertaken, purportedly in compliance with your lordship's order, and there is no remote compliance, I will not have to seek to any rejoinder. I'll rely on the documents filed by them. I'll show their pleadings, I'll show their data, and I'll show each one of them is in direct violation of the formulations of your lordships in para 260, para 280, and 360 of the holding in 22/5/2024. This is not a vacant exercise trying to bide their time. It has resulted in a statutory consequence of the list under the BCC Act being amended. Now, I am affected because it alters the landscape of admissions as far as I am concerned, or the affected students are concerned. Now, kindly see the consequences. Your lordships have already dealt with those submissions as to whether a PIL could be maintained. I will indicate to your lordships that the same circumstances your lordships have indicated to hold that the PIL is maintainable in these matters continues to writ large. There is no publication of the primary data. There is no publication of the social enumerating factors. There is no publication of any of the applications filed by any of the intending communities. There is no publication of the Backward Classes Commission's reports, 4 of them. I am told, I'll indicate to your lordships, they are not even cursory. Your lordships have said it is a deliberative democracy. There has to be an application of mind. I'll indicate to your lordships that there is not even a lip service of consideration. 4, they have arrived at re-quantifying the reservation from the existing 10% to 17%. Now, that is an activity relevant for 2012 Act also. There is no state population figure. There is no population figure of any of the communities that have been identified. There is no contemporary figure of public employment and the people who have occupied those positions. 2014 is the freezing data. Between 2010 to 2025, 140 communities had the benefit of reservations. The data would alter. There is no data. But the state has decided that it will have to be at 17%. Your lordships have said, in the opinion of the state, adequate representation will be.
That has not yet been done.
That has been done. That has been done. I'll place before your lordship.
17%.
Yes, I'll place it before your lordship. I'll place it before your lordship. Absent population figures of everybody, absent public employment figures of the figures now included, I would ask myself, it could have been 25%. It could have been 33%. On what basis was it reduced to 17? The incidental replication of Section 5A of the Act. If they have to validate their action, they have to remove the basis of the judgment, or they have to await the Supreme Court ruling. They can't reinvent the wheel and recause the same consequences. I'll just take 3 minutes of your lordship's time to read 5 notifications they have issued, which is of some statutory consequence. They have not said that they won't be acted upon for the present year.
Sir, just tell us, suppose today, before the Supreme Court hears, whatever faulty method they have adopted, in derogation to our decision, suppose today they said, they take a decision that yes, we have amended the schedule on the basis of this commission recommendation, and tomorrow all pending selection processes would be guided by this new data. That situation has not occurred.
That is the situation today.
Where from we will find
your lordships will see as to what is stated in the pleadings in the commission. I will indicate to your lordships as to what are the consequences arising from these notifications and see how imminent that process is. because they are not saying that the commission.
So then, sir, we have to give them an opportunity to reply.
Well, as of today, if your lordship just gives me 3 minutes time, I'll indicate the ramifications of the exercise and its culmination in these notifications. If your lordship's conscience is satisfied that what is now required is the imminent process of legislative notification of these processes, then we are looking at an inevitable consequence to be provided as a fait accompli to me. I am not seeking interdiction of a legislation, but I am saying the factual predicate which is underlying the process is so flawed.
Where they have said that they will be implementing this in the.
Well, it's that in this particular,
that
is not stated in the writ affidavit. It is not their case now that the present admissions in 2025.
That is not their case now.
No, I'm subject. Nor is it their case.
The one single judge has said that you follow the 66.
Nor is it their case now that they will be following the pre-2010 classification for the present purpose, because the pre-2010 classification is also amended now. 64 out of the 66 communities are reintroduced. They are interspersed between A and B. The entire landscape of the OBC figures has now changed. This is how far-reaching the fact-finding purportedly innocuous exercise has been left. May I just indicate to your lordship?
Legislative process,
Yes.
and we don't do it.
Yes.
Because the theory of separation of powers is very important.
Right.
At the end of the day, you have placed a certain data before the legislature for its consideration.
Correct, my lord. Correct.
Now, the legislature may accept, may reject, may modify or do whatever it deems or remand matter back to you. That is the wisdom of the legislature.
That's the legislative affirmation.
That is the wisdom of the legislature.
Right.
Now, at this stage, there is good, bad, indifferent, an application from their side.
Right.
Questioning some issues or whatever, bald or otherwise.
Then, my lord,
there is no response as yet to your affidavit in opposition.
Absolutely.
Now, unless the pleadings are complete.
Yes, my lord, kindly do that. Kindly give us a short date.
Time we suppose tomorrow.
Yes.
In the process of these 7-8 days, unlikely 7 days or another 3 days, 4 days.
I cannot answer that, man. I cannot answer that.
It is unlikely that the legislature will just pass everything and implement the data. Is that what
the legislature has passed?
The object is to amend the 2012 Act to bring in a legislation. That is how you did it earlier. Because you include first ever notifications in 2010, then you brought the 2012 Act and you said you brought in the schedules. Now we expect that the same procedure to be followed, because after all you have a 2012 Act staring in your face. If the Act were not there, if the Act itself was not there or repealed or whatever, then under the 93 Act written with Article 16 of the Constitution, you could have done exactly what you have done now. But with the Act staring at you, could you have, without a bill for bringing these classes, it still amounts to an executive action seeking the approval of the legislation, which is not. Let us hear.
Actually, I want Mr. Ekmala says, I am showing your lordship's recruitment notification issued showing OBC A and B again.
Very good. That is covered by the undertaking given before us.
No.
In the contempt proceeding?
Contempt proceeding, they have said the principal secretary.
Giving it to the new level executive orders effect.
Pardon?
Giving effect to the new executive orders.
Giving effect for the purpose of commencing the selection process, no?
New. Obviously, what we in the contempt
Mr. Sannal, there are very diverse facts. In contempt, when you showed us that they are proceeding in violation of ours,
that's old one.
Old one.
He said, by your lordship.
Now
they have but done. They have published by executive order 100-point roster, OBC A and B, and they are now proceeding on the basis of that new executive order.
Processing, how we will find? They have commenced the selection process.
Kindly have a look at the notification.
So why didn't you bring this on record?
Yesterday. Well, every day we are getting it. On and on.
I have to carry on with the process. Everything cannot be stalled. I have to give admission. What happens to the students? But my learned friends can challenge it. I don't say so. But
Mr. Dotto, you can easily do it taking into consideration 66 OBCs. 66 OBCs we have not touched.
The other, the included parts or the newly
No,
fresh.
if it is the stand of the state that let the court say whatever they want, we will, in the taking pendency of the proceeding, we will include OBCA, OBCB on the basis of strength of executive direction. Then, sorry, we have to intervene then, Mr.
May I say this? May I say this, Lord?
You are